When a place that is supposed to keep you safe fails to do so, who ends up paying the price? All too often, it's you. I'm Brad Parker. I'm the attorney you want but hope you never need. If you or someone you love was hurt because a property owner decided to cut corners on security, you deserve answers and you absolutely deserve justice. I want to explain how these inadequate security claims work, why they are so important, and how we fight to hold negligent property owners accountable for their choices. Every day, people go to work, shop for their families, and return to apartments expecting to be safe. But that basic expectation is often broken. This isn't because of random chance, it's the result of specific choices. Think of the parking lot with insufficient lighting that conceals an attacker, the broken locks and gates that offer an open invitation to intruders, or the security cameras that don't actually work. Sometimes there is a complete lack of trained security personnel where they are clearly needed. These are not simple oversights or accidents. They are cost-cutting decisions that place profits over people and put innocent individuals directly in harm's way. Legally, these situations are known as inadequate security claims, which are a type of premises liability case. To successfully hold a property owner accountable, we generally have to prove 4 key things. Let's break that down. First is the duty of care, which means property owners have a responsibility to provide a reasonably safe environment for their visitors and tenants. Second is proving a breach of duty. This happens when an owner fails to provide that reasonable security, such as leaving cameras broken or stairwells dark. Third, we establish causation by connecting the dots. We have to show that their failure to provide security directly led to the injury, for example, by proving a violent attack happened in the exact spot where the lights were known to be out. The fourth element, foreseeability, is often the most important. We have to ask, could the owner have reasonably known that a crime like this was likely to happen? We look at past incidents on the property, local crime rates, or even prior warnings that were ignored. Courts have long held that owners are liable when danger is foreseeable. This concept is what turns an incident that seems like bad luck into a case of preventable harm. If a property has a known history of problems or clear risks, the law expects the owner to act on that knowledge. We understand the pressures property owners face, including rising insurance premiums and other costs. But the law, in simple human decency, does not allow companies or landlords to trade their tenants' safety for savings. You might hear a defense like, "We couldn't afford it," but financial hardship is not a free pass when the harm was foreseeable and preventable. We've seen defendants try that defense, and we've successfully shown that people's safety can't be just another line item to cut from a budget. When we build a case, our process is thorough. We start by investigating the scene, where we gather police reports, maintenance logs, and any available security footage. Then we document patterns of danger by looking for prior incidents, ignored complaints, or history of unrepaired equipment. We bring in security and forensic experts to testify about what reasonable safety measures should have been in place. Finally, we connect all the evidence to show a jury that the owner's choices led directly to the harm that was suffered. We have handled many cases involving broken locks, dark parking lots, failing cameras, and the absence of security at high-risk venues. Recently in Texas, we secured a verdict for a woman injured by stairs that were inherently unsafe and lighting that was inadequate. That client was owed better, and we made sure their voice was heard. As budgets get tight, we are seeing a couple of worrying trends. Property owners are reducing security staffing and deferring necessary maintenance on cameras and lighting. We are also seeing more attempts to use economic hardship as a legal defense. This makes careful documentation and experienced legal help more important than ever. If you or a loved one has been hurt because a property owner cut corners on safety, there are practical steps you should take, and we will be with you every step of the way. First, seek medical attention immediately and make sure all your injuries are documented. You should also preserve any evidence you have, like photos of the scene, text messages, or even the clothes you were wearing. Be sure to get copies of police reports and all incident numbers and save the names and contact information of any witnesses. Most importantly, call a lawyer who has experience with negligent security cases. We will step in to collect the evidence the property owner should have kept, like maintenance logs, security contracts, and video footage. We'll use our expert witnesses to show what reasonable security would have looked like and how it could have prevented your injury. We treat you like family, and we fight tirelessly for you. We handle these cases on a contingency basis, which means there is no fee unless we win. Your safety is not an item on a budget. When property owners choose profits over protection, we hold them accountable. If you've been harmed, call Parker Law Firm. We'll listen to your story, investigate what happened, and fight for the justice and the recovery you deserve. You don't have to face this alone. Call us for a free consultation today. This information provides a general overview of premises liability and inadequate security claims. It does not constitute legal advice. Individual cases vary, so you should consult an attorney to discuss your specific situation.